Urgently, I had to withdraw because a copy of the order was not with me. Well, I filed along with a copy of the order along with an affidavit. Praying for a listing tomorrow, Lordship.
Take a chance, day after tomorrow.
Well,
Day after tomorrow.
Friday. Well,
Yes. Day after tomorrow.
obliged.
Obliged.
Number 10.
My lord.
My lord, I beg to mention item number 11. My lord, I am praying for an accommodation of 4 weeks. My lord.
Who is on the other side? Lord, I'm Mr. 302.
Talk so, my lord.
Why?
I need some more time to prepare, my lord. Honestly.
Paper, I think paper book is
Paper
available.
book is ready, my lord. I need some more time to prepare, my lord.
At the request of the appellant. Item 11.
11, item number 11, my lord.
11. Criminal appeal 13 of 23. Post after 4 weeks.
My lord. Deeply obliged. my lord.
From the daily list, item number 1.
Job line. This is that appeal against 302, Millets.
302.
Millets. This appeal has already been admitted. The paper book has been filed by us. Well, it's just one issue came up yesterday when we were looking into the matter. Certain documents from the LCR Millets need to be examined so that we can assist your lordships with that. Because there's a very peculiar question that has come up. So I was praying if your lordships kindly grant us a little time, Millets, we would and give us leave to examine the LC records, because the LC records have been called for by your lordships.
It is represented by the counsel appearing to the appellant that some more documents need to be filed. and short time. When do you want? April?
My lords.
Who's the make April? Yeah. April. Lordship.
My lord, may kindly grant us liberty to examine the LC records, my lords. The lower court records.
Since we call for the records, you are entitled to apply and get a copy.
We don't need the copies, my lords, just to examine it.
It's available here.
My lords.
Just come. What is the procedure here? Usually you'll have to, there we will be filing an application to scrutinize the record.
My lords, we usually make an oral submission before the court and your lordships grant us liberty to examine the records in the presence of a court officer.
Oh, there is no procedure like that.
Otherwise, we won't file a formal application. My lords.
Yes.
Right.
Yes, exactly.
Item number 3.
Last order. Last order. Last order.
So the additional documents,
Additional document.
last time it taken time to file an additional documents.
May it please, Lordship. Lordship, what has happened, we have just received instruction from the inquiry officer, Lordship, as per the order dated 4/3/2024. So,
Just-
last order is of 8/2/2024, Lordship. The instruction that we have received, Lordship, the matter is fixed on 11th of March for inspection of the documents. These documents were required by the charge officer. So the inquiry officer has fixed.
No, what is the order that is on the challenge?
My lords, this is a
This
PIL.
is the PIL.
Oh, this is a PAL.
PIL, my lords, concerning a certain
Certain irregularities that was committed in the
police
police
department.
department. So court had taken up this PIL. And court is monitoring, Your Lordship, the proceedings of the inquiry. Disciplinary proceedings, Your Lord.
So where,
So, Lordship, what has happened as per the
what do
order?
you want?
Lordship, the matter is coming up on 11th March for inspection of documents. The charge officer
Supply of documents to the charge sheeted officer.
My lords.
certain additional documents, and so the inquiry officer has fixed 11th, directing the AIG to produce the documents. There are 6 number of documents. So he's
The matter is
fixed on
taken for
11th.
hearing. It is represented by the state. Then the inquiry is fixed on 11th,
11 for inspection of the documents,
11/3/2024.
and the next date of hearing is fixed on 26 March.
26.
Inspector and the matter is for the inquiry officer fix the date as 11th March 2024 for inspecting the documents and permitting the officer, hearing officer.
The EIG has been directed to produce the documents, and the charging officer can inspect the documents on
He'll
11.
inspect the document and if required, he will take notes or he'll seek for documents.
And then the next date of hearing is on 26 March. Your Lordship.
And the inquiry and the proceeding and the inquiry is fixed on 26 March. Registry is that this matter.
My lord,
In April.
may I get 2 minutes, my lord, to submit, my lord? I am the charged officer, my lord. I am the respondent number 7, my lord. Now, my lord, the very purpose of filing this PIL, my lord, has been achieved, my lord. Now, 7 FIRs have been filed. Out of 7 FIRs, 6 has been charge sheeted against me, my lord. And the departmental proceedings, my lord, as the learned double AG has submitted, my lord. The departmental proceedings are proceeding, my lord. Proceeding, my lord. Now, my lord.
See, from the pleading, it appears very serious.
Exactly, my lord.
We'll monitor it. We know what is happening.
The court has already passed the order
My lord.
that it needs monitoring.
My lord, I would humbly state that, my lord. Yes, the charges are very serious, my lord. I have an opportunity to prove my innocence, my lord. Now, my lord, what I said is, this PIL itself has been filed in the first place with ulterior motives, my lord. To score ends only, nothing else, my lord. And because I have never got this opportunity to submit before my lords, Therefore, today I am submitting, my lord. Now, what had happened, my lord, when initially this PIL was registered, my lord, on the first day itself, I won't blame anybody, but the first day itself, my lord, this court has taken cognizance. Basis of that, one after an FIR was registered, I was arrested, my lord. I was thrown behind the bars, my lord. 7 FIRs have been registered, one after another. Ultimately, no notice was issued to me from this honorable court. I had to go to the Supreme Court, my lord. And in the Supreme Court, my lord, I represent myself for the respondent number 7, my lord. And what happened was that since it was a verbal exchange, my lord, the honorable Supreme Court said that you are impleaded as respondent number 7. Why don't you go back and contest your case there? So I have withdrawn with the liberty to avail remedies, madam, sir. Thank you. The remedies available to me, my lord. After that only, my lord, I have entered my appearance. Copies were served to me, my lord. Now, my lord, kindly look at who he. Now, there was a high-level fact-finding committee constituted, my lord, which I didn't even know, my lord. They were constituting finding facts against me. I didn't even know. I was a AIG, my lord. And this report was submitted to whom? This report was purportedly submitted to the Shillong Times, my lord, where the petitioner number 2 is the editor-in-chief, my lord. And now the editor-in-chief, the petitioner number 2, against whom I have already filed a criminal defamation case since the year 2019. And that is pending, my lord, now. That is pending before the Chief Judicial Magistrate, my lord.
See, already the court has decided to monitor
Yes, my lord.
the proceedings.
My
So
lord.
we are adjourning it. We are not going to render any finding.
My
If
lord.
there is any lacuna on the part of the department
My lord.
in proceeding,
My lord.
then we'll, because already the contempt was sought to be initiated in the Home Secretary.
Exactly, my lord.
Then ultimately his apology tendered
Yes.
was accepted.
Yes, my lord.
So
My lord.
we will adjourn the matter. We are not going to pass orders. We have
My lord.
recorded that the matter is fixed on 26.
Yes, my
You
lord.
verify the documents on 26.
My lord.
11. In the light of the judgment of the Supreme Court, now where if you want, you can scrutinize the document.
My lord.
If it's a voluminous document, you can take notes. Or 11 pages, you can take Xerox.
Yes.
Subject to the rules applicable, guidelines applicable, they may furnish a copy or permit you to take a copy. That is all.
My lord.
We are not going to follow any orders closing the PL.
My lord, that I will do, my lord. And I have been suspended since 3rd of November 2022, my lord. Now, my lord, there is a Premnath Bali's case reported 2015, volume 16, SEC 415 very clearly says that 6 months departmental proceeding has to complete. If not, then 1 year, my lord. 1 year I have been under suspensions, my lord. How do I survive? I have fallen from grace, from the glory, my lord. I have been put behind bars for 6 months, my lord.
Whether these matters can be adjudicated in this
My lord,
PIL.
that's why I'm
He has
saying that,
remedy
my
under
lord,
law.
this PIL is
His remedy is under law.
ulterior motives, my lord.
You have not challenged
My lord.
the suspension order.
No, my
There
lord.
are 2 or 3 judgments of the Supreme Court.
My lord.
Where if the inquiry proceedings is not completed, a criminal case is not completed,
My
not
lord.
department inquiry.
My lord.
Then 1 year, out of what the case you refer to is that the criminal case, the charges must be similar. The charges in the department proceeding and criminal case are identical.
Yes, my
The
lord.
Supreme Court says, if the criminal case is not completed within 1 year,
My lord.
department proceedings can go on. Now, in other paragraph, it says that you can be posted in a non-sensitive post. That
lord.
must be the
Yes,
decision
yes.
of the Supreme Court.
My lord.
Correct?
Yes, my lord. My lord, may kindly note my submissions also. Just one note, because I am saying that I'm seriously challenging.
No, it is represented that the petitioner, you came out on bail.
Yes, my lord, I'm on bail now.
Petitioner was incarcerated and came out on bail. More than half a dozen charges have been framed against the petitioner, against the 7th respondent. He has been placed under suspension in 2022 and that more than a year has gone by, no progress have been made. Hence, the petition should be reinstated in service.
Respondent 7.
Sorry, respondent 7. So correct, please note correct. Respondent 7 shall be reinstated in service, and it is open to the department to proceed in accordance with law. So, since the petition, the relief sought for, the submission made by the petitioner cannot be considered in this writ petition, and depending upon cannot be considered in this writ petition. So, if any challenge is made to the suspension order, depending upon the materials available before the court, the court may decide as to whether a suspension should be continued or should be placed in a non-sensitive post. Close the matter in first week or second week of April. So ensure that the dates are spread accordingly. Yes.
Item number 4.
See, 1 minute. Take out those. You'll be having judgments which we have read. Madurai also, the first judgment I wrote, sitting singly and also on division bench, putting the 2 judgments, that 1 year period or no. Take out that. Yes.
May it please your lordship. Lordship, we have already taken steps upon the respondent, and affidavit of service has already been filed on the 19th Feb 2000.
Where is the proof? On
19 February 2024.
19?
February 2024, lordship. We have already taken.
What's the date she says?
19 February 2000.
19th February.
Yes, lordship. Affidavit of service has been filed on this date.
Person has received it.
Yes, lordship. He has received it on 5th January.
Delivery of honorable record so and so, sir, respectively with reference to honorable sir, intimate that the registered letter, barcode number so and so was delivered and received by Anjan Kar Das. Who is the respondent here? Ram Fasteners.
Shri Ram Fastness.
You have received it.
Yes, lordship.
Which page, ma'am? Where is the proof?
Lordship, the affidavit of service that we have filed on 19th Feb 2024, annexure C, page 7.
Page number?
Annexure C, page 7.
Annexure C. When the matter is taken up for hearing, the petitioner has filed an affidavit of service enclosing annexure C, showing the proof of service duly served on the respondent herein, and the article sent in RA 3010001765IN was delivered to the respondent on 5/1/2024. How many days delay?
Lordship, delay of 52 days.
Note of the submission. Delay is condoned. Having satisfied with the reasons. Yes.
Highly obliged, Lordship.
Item number 5.
Please, Your Lordship.
Lordship, I humbly pray before your Lordship to kindly take up this matter at the end of the board. At the end of the board, Lordship.
79 days delay.
Yes, Lordship.
Who is on the other side?
My Lord, I'm beside Mr. Verma, who's on VC, my Lord.
Yes, Mr. Verma.
Your Lordship, actually, we want to file the objections upon this continuation of delay application, Your Lordship. So, Your Lordship may kindly grant me some 2 weeks time, and the wakalatnama are being filed by Mr. Sudev today, my Lord, with the registry.
So do you have any serious objection with regard to the delay of 79 days?
Because they have not given any sufficient cause, my Lord.
Well, what is the reason given by you, madam?
Lordship, in this matter, Lordship, the learned DSJ has some important submissions to make. So I humbly pray if this matter can come up at the end of the vote.
Please answer a question, madam. Now we want to give some relief to you in the absence of your senior. If you give a genuine reason, then we will condone. Otherwise, we'll have to accept the case on the other side. Then we'll reject it in the presence of your senior. That is all.
Uh,
Yes, sir.
Lordship, in para 4,
Yeah, I have read. Before you open the page, I have read the entire thing. Yes, Mr. Verma, we'll condone the delay. Sir, yesterday put them the same reasons. Condone. Delay condone. Delay condone.
Item number 6.
You can tell your senior that you are vehemently arguing.
Oblige, Your Lordship.
Yes.
highly obliged.
Paper book for the petitioner to appellant to file paper. Yes.
Item number 7.
Lord, this is that matter where I filed a common appeal, my Lord, common appeal against the main order and the review order. So, Lord, I seek liberty, my Lord, to permit me to withdraw this and permit me to file a fresh, my Lord. I'll file 2 separate appeals, my Lord, against the main order and the order of review, my Lord.
2 appeals.
Yes, my Lord.
You got the judgment of Supreme Court?
No, my Lord, but I feel your Lordship's is very much correct.
This is a judgment of the Supreme Court last year.
My Lord. Liberty may be granted, my Lord. I'll withdraw this.
Liberty is given to the committee to withdraw this appeal. Sorry, with the miscellaneous petition, with liberty to file fresh petition.
Deeply.
Oblige, Your Lordship.
Item number 8.
May I be pleased, Your Lordship? Your Lordship, I'm praying for 1 week's time, Your Lordship, on behalf of my senior.
302 matter, Your Lordship.
34.
30.
34 is there.
No,
302 and
302,
326.
302 only.
302. And based on confessional statement, 164.
Huh?
Based on 164, confessional statement, she admitted lady killing her husband.
2021 matter.
Your Lordship, my senior was ready, but today morning he had some medical emergency, so he had to go to the hospital, Your Lordship.
You can argue.
Lordship, some time will be given, Your Lordship.
Sometimes the junior argue may try to find out some lacuna, either to discharge or to reduce a punishment. The senior argues will be no more careful to confirm it. The request. What's the matter? On so-and-so date. Take the date in the afternoon.
Your Lordship.
Because today we have posted 14 matters. Out of it, 12 are criminal matters.
Mine was 3 criminal matters, Your Lordship. I thought at least one would have happened.
Your Lordship is making a similar prayer for the next item number 9 also, Your Lordship.
Review item 8.
Yes, Lordship.
That is also 3 or 2.
Yes, Your Lordship.
Same incident or?
Different.
Item number 10.
You be ready.
Your Lordship.
Be ready.
Your Lordship.
Ready to argue the matter. That's all. See, if there is any problem, we'll ask your senior to clarify and address.
Your Lordship.
Use the opportunity to address this. You see, addressing before the High Court and before the first bench is a very good opportunity.
Your Lordship, yes.
Understand? Don't miss the opportunity. One of you will become a senior advocate. One of you may adorn this bench at a later point of time. Unless the proper exposure is there, it will be very difficult. Nobody should say that whenever X is coming, he'll seek only adjournment. That should not be the impression. You don't give that impression to the court. Yes.
Diplomat. May please, Your Honor. May please. Your Lordship. Oh. May it please Your Lordship. On the last occasion, this matter was
So
part
this
of
matter came last.
Yes.
This item number 12.
Yes.
Then
To
13,
refresh
14.
Your Lordship's memory.
The last case.
Yes. Facts is like this, my lord. On 29, my lord, 12/2011, my lord, a person was missing.
This is you argued, you noted.
Yes.
2912 missing, 21/12/2011 FIR was filed, PW2, PW3 and 4 was examined,
My lord.
and case was registered on 14/2/2012
My lord.
and arrested on 28/12/2012. Everything was.
Yes, my lord. It would my duty, my lord, wherein, my lord.
Don't worry, I will not forget.
Yes.
I will forget only after delivering the judgment.
My lord, may I take your lordship to page 2 itself, my lord, which is the FIR lodged on 31/12, my lord. 31/12/2011 at page 2.
3112,
2011, my lord.
1 miss.
2A, it will be 2A, my lord.
3112/2000,
11, my lord. Yes. I'm reading it, my lord.
page
2A, my lord.
2 capital A.
Yes, capital yes. And this will, my lord, take away the evidence part with regard to this informant side, my lord. PW3 and PW4. We come to inform you that so-and-so, is it about so-and-so, resident of so-and-so was missing on 29/12/2011, and when he was charged by the villagers people, it was found that he was beaten to death at a place called Brewer Ilaka so-and-so. The incident took place around 9 p.m. We are hereby requested to find out the killers and arrest them as per law. So these are the two persons who have signed it, my lord. Will kindly see right and left, PW3 and PW4. So with regard to
that occurrence took place on 29/12/2011, and the place, my lord, will kindly note down the place of occurrence. Briwar Ilaka Nongkle. This is very important.
Yes.
Now coming to the evidence, on the last occasion I have taken this honorable court with regard to the evidence of PW1 and PW2, who happens to be eyewitness. As for these particular two eyewitness, my lord, I have taken through their 164 statement, also 161 statement, and the substantive evidence.
It was given after 65 days. Yes.
65 days, yes.
Yes.
And my lord will kindly see in their evidence, substantive evidence before the court, they have stated they have seen this accused appellant beating them. But with what? It was not there. Nothing was there. Because I am appreciating that fact to appreciate the postmortem report also. And this particular person was silent altogether, my lord, 65 days, all of a sudden comes in and their 164 recorded, my lord.
Yes.
Yes. Now PW3 and PW4 is very important, my lord. Who happens to be the informant of this case, my lord. I take this honorable court to their evidence, that is at page 43. 43. Now, whole versions, my lord, their 161 statement also I have shown it before this honorable court and read it also. Now, according to them, PW3, my lord, 29/12/2000, as usual, my son came out from home in Briwar, but at around 9 p.m. I received a phone call from my son's wife, that is PW4. Grimly Swans were asking about the whereabouts of my deceased son, and I told the wife that maybe the deceased son was still at work. This was never been part of the 161 statements. After talking to my deceased son's wife, two men came to my house, namely so-and-so, and this has the PW1 and PW2, and informed me that my son, the deceased victim, was murdered at Briwar. Now the place, my lord, why I pointed in the FIR, my lord, and this, my lord, happens to be different, my lord. On inquiry whether they know the people behind the murder, and they told me that it was Tom who murdered him, but I do not know about the details of Tom's identity. So this, my lord, is been for the first time in the court. Never been in 161, FIR is on 31/12, never been mentioned. Now, my lord, after I heard about this news, I went to neighbors' place, calling them to accompany me to Briwar, but we could not go as it was late at night. However, my husband, late so-and-so, went to Briwar, the place of occurrence. When my husband reached the place, we could not find his deceased son, and he returned back home on the same night. On the next day, my family, along with villagers, so-and-so, went to search of the deceased victim and found the dead body, and I do not know the place where the dead body, where they found the dead body, and I do not went along with them. My lord, the next day, my lord, 38 dead body has been recovered. 31/12, police came to our house and took the body of the deceased victim for postmortem at so-and-so CHE. On the same day after the postmortem, we took the deceased body back home and conduct the last rites. Again on 31/12, I file an FIR, my lord. This I have read it, page 2A. So neighbor whispered with regard to coming to know about the assailant, my lord. And it is for the first time this statement has been made for the purpose of corroborating, my lord, the prosecution case. Never been in the previous statements, my lord.
So according to PW3 version,
yes,
runs counter to page number 2, capital A.
Yes. And she will exhibit the FIR also, my lord. My client's name is missing. So for coming to know with regard to the assailant name, that is also been missing. It is missing in 161 also. So my lord will kindly see the cross-examination part, which I marked as very important, my lord. Why? First two, my lord. It is true that I filed the affair after the delay of 2 days from the incident. Admitted facts. On 29/12, I received the information about the victim by the two persons named so and so and so and so, as they came and informed me in my residence. So this is an admission being made, an admission during cross-examination, but which, my lord, is contrary to 161 and the affair itself. I know it, who had the assignment on 29/12 itself, my lord, but I did not disclose it in my affair, my lord. I do not disclose it in my 161 statements, my lord. Now the last line again, my lord, will kindly see. It is true that I found the dead body of the victim on 30/12/2011. Admitted facts. And with all respect, my lord, so far Indian evidence is concerned, Section 17 of the Indian Evidence Act defines what is an admission. An admission is a statement, oral or documentary, my lord, which suggests any inference as to fact in issue or relevant fact. The relevant fact is who are the assailants. Not been. And it admitted that on the date of occurrence only, she came to know. But he did not mention. This is nothing but an afterthought, my lord. Now, my last line, my lord, can you see the two informant came at my residence at around 9 p.m. to inform me about the incident. Can it be, my lord? They see it at 9 p.m. occurrence, my lord. They came into the village and informed at 9 p.m. And these are all for the first time. So the next, my lord, will kindly come to the PW4, another informant, who happens to be the wife of the deceased. Same evidence, my lord. At paragraph 3, I am reading it, my lord. As usual, my husband left my home in the morning for work at Brewar. Usually, my husband came home from work by evening time before 7 p.m. However, on the particular night, my husband did not return home at about 8:30 p.m. to 9 p.m. I called up my mother-in-law to ask about my husband. She said that maybe this is still work and he will coming home. Till this part, it is okay. On the same night, after a while, a group of people from my village came to my house, and when I asked them as to why they came into my house, they did not tell me the reason until the next morning. They told me that my husband has been murdered, and just after here, then I fell unconscious. So she came to know with regard to the assailant on 38th. And thereafter, on 31st, she has been the signatory of the affair. Thereafter, during investigation, 161 has been recorded. No whisper with regard to this, my lord appellant. Then, my lord, on 30/12/2011, the elders of my family and the villagers of so-and-so village went to search of my husband, and they found my husband's body somewhere nearby the area of Brewar. With regard to, my lord, affair, my lord, date at a place called Brewar. In the affair, I have taken your lordships, and my lord has noted at 2A, the place Brewar Ilaka. So, my lord, here she says, on 30/12, so they found my husband's body somewhere nearby area of Brewar, at that place only. And PW3 stated that when the villagers went, they did not find the body. On the next day, at some other place, it has been found. They brought the deceased dead body to my house. I cannot explain the condition of my husband's body. I remained unconscious even at the time of arrival of the body in my house. On 31/12, the body of my husband was taken to so-and-so postmortem. And just after the postmortem, we took back the body of our village, funeral, so-and-so. So I handed over the affair to the so-and-so. Exhibit 3 is the affair. She exhibits the affair. So, because she is the informant. Now, the cross-examination 8, my lord, will kindly see, 46 page. I heard that it was Home who murdered my husband. And she came to know with regard to this on 38. She did not disclose it in the FIR, nor neither in 161. The cross-examination part, my lord, will kindly see. 2, my lord, under the number 2, I am reading it. I am skipping 1, my lord. It is not a fact that my deceased husband had called me over phone on 29/12/2000 to say that he has been assaulted by an unknown person. Now, yes. So, my lord, will kindly see, in every criminal cases, it should have been a part of the investigation, whether call was made or not. Whatever I am saying, my lord, the witnesses cannot be the gospel truth, my lord. Some may be vested interests, some may be influenced by family members or otherwise. It is the duty of the investigating officer to cross-verify with regard to authenticity of this. Any call being made is subject to, my lord, electronic record evidence. Now, for that purpose, Evidence Act has been, my lord, amended on 17/10/2000. The document part, my lord, definitions, electronic records becomes part of it, my lord. On that day, Information Technology Act also came into force. 65A, 65B has been introduced, my lord, with regard to the manner to which it is to be proved in the court of law. Now, in that circumstances, one can come and make a statement that I made a call. It is subject to verifications.
If it is 65B, a certificate is required.
Yes, by the person concerned, my lord, by the service providers, my lord. Wherein call records, CBR, my lord, call records is been given, and the person issuing the call record with a 65B certification is required. The law was changing all along, but now it is been confirmed. The previously law was that certification is mandatory. Subsequently, it has been there that it is not mandatory. Now the law has been very clear that with regard to electronic record, there is every possibility of foul plays. So certificate is mandatory. So in that case, my lord, with regard to this,
So do you mean to say the person who has recorded it state that I have recorded it? Is it not sufficient?
no, my lord, this is oral testimony as to a content of a document. When electronic records becomes part of the definition of document after 17/10/2000. So, my lord, 22A in the Evidence Act has been incorporated. What is that? Oral testimony as to the contents of a document is irrelevant unless and until secondary evidence at least has been given. And that is it for a purpose. Similarly, previously, before amendment of 1872 Act, so far with regard to this same law, oral testimony as to a content of a document is inadmissible unless and until secondary evidence is given. 22A 17/10/2000 has been introduced. Oral evidence as a content of an electronic record. So, for that purpose, my lord, the adverse presumption is in my favor, my lord. I need to do this. Yeah. Now, why I am pointing out to this call, in 161, call has been made other way around. Here it is other way around. Next, my lord, I take your lordship to PW5, Reliance, my lord, Pringap.
Which one, sir?
PW5, my lord. Page 47, my lord. I have received summons to depose in the court today. I know about the case that this is so-and-so is my nephew and I am one of the inquest report witness. On 29/12/2000, my sister so-and-so informed me that her son so-and-so, so the deceased has been murdered in so-and-so at night time. Then on the next day, I along with the people so-and-so went to Brewer to search the deceased victim. On searching there we found his dead body in that particular place itself. We found his dead body lying in the pool of blood, and by looking at the injury, it looks like he has been murdered by a sharp object. Now, PW1, PW2 is silent with regard to the object that has been used for inflicting injuries. I do not remember the date and time when I signed the inquest report that has been given by the police. By the remainder, the police gave me the inquest report and put my signature exhibit for cross-examination. I do not remember which document which the police brought to me, but I have signed it at my residence at so-and-so, but I did not remember the date and time. Inquest report, my lord, has been at the place of occurrence. It's been brought to his house. He signs it. What is the evidentiary value, my lord, with regard to this? I do not know the content of the document before I sign. He doesn't know about the contents, my lord. As far as criminal law is concerned, my lord, only by exhibiting a document doesn't prove the contents of the document. The contents is to be separately proved. That's been the standard with regard to the Evidence Act, my lord, itself. Now, his document has been brought to his house and he signs it. He doesn't know about the content. It's an admission on the part. So what is the evidentiary value of these particular witnesses, my lord? I'll not reading rest of the lines, my lord. Next is PW6, my lord, Dr. Wanda Demon. Yes. My lord, the relevant part is 4, my lord, will kindly see. Page 48. I did the postmortem, my lord, for on 31/12/2011 at 2 p.m. During postmortem examination, these are the injuries been found, my lord. That has been mentioned, 5 and 6, my lord. There is a chop wound, 6, my lord, chop wound on the scalp of the left parietal region, so and so. So there is fracture of left parietal bone, so and so. These are the injuries are concerned, my lord. Now, my lord, nobody has been disputing the injuries part. So for the cross-examination part is this very relevant, my lord, will kindly see. When we reached the residence of the deceased person, the dead body was kept lying on the bed and we conducted postmortem there itself. Can you imagine, my lord? The body has been taken to CHE, the other witnesses says. Body has been taken to CHT for postmortem. His witness has stated doctor on oath. Can a postmortem be done at the residence, my lord? I'm sorry. The jail manual, my lord, the police manual, everything talks about it, my lord. Postmortem at residence, my lord, itself. And, my lord, that's all will, my lord, clear all these things, my lord. PW7, my lord, will kindly come to page 50.
1 minute, 1 minute.
This is the quality of evidence on the basis of which a person is under incarnation, my lord, and for life.
This itself will not suffice.
My lord,
This itself will suffice. Doctor's evidence, postmortem evidence.
my lord, so far postmortem is concerned, my lord, postmortem report is itself is not a primary evidence, my lord. It is used 7x for the purpose of contradiction, my lord. Secondly, my lord, there is a provision for spot inspection also when the dead body is not in a condition of removing to hospital. Oh, my lord, I'll come to that, my lord. I have got that, my lord. So where is the, my lord, where is the bar not to hold, my lord, postmortem at the spot, my lord, or at the residence, my lord?
Where it is stated that the body was not in a condition to be taken to the plane for postmortem.
My lord, I'm just stating the circumstances when, my lord, spot inspection can be
So you will be having a lot of equipment to do the postmortem, sir. Just like they can't do like that.
My lord, if I may, the very purpose of, my lord, conducting postmortem is to find out the nature of injuries and to find out whether it is a mortem or anti-mortem. That's all, my lord. Unless and until this fact is not, my lord, when the medical doctor who is examined.
When it takes place, police can come to the spot, take the FIR, record the 161 statement, ask the doctor to come to the spot where incident, there itself they can do the postmortem.
True, my lord. True, my lord. True, my lord. There again, my lord, my respectful submission would be, my lord, just for the defect, some defect in the investigation, my lord, cannot throw the, my lord, evidences, ocular testimonies, which otherwise, my lord.
If you find there is a defect in the investigation, then we have to. What about 173.8? 173.8 alone is already.
I'm coming to that. I'm coming to that. Also, before I come to my I open my case, my lord. Let's take a pause and, my lord, look at the scenario, my lord. The background.
See, what is it?
My lord, before I open my case, my lord, let's try to recapitulate the, my lord, the situation under which the
What we pose is the postmortem can be done at the residence or any place,
my lord,
of the doctor.
Under special circumstances, it can be done. I'm coming to that, my lord. I'll come to that, my lord. I'll satisfy.
Only thing is, has anything been stated about the special circumstances in the evidence?
Nothing, my lord, but there again, my lord, inference can be drawn, my lord, for the fact that the body was, my lord, taken to the residence and they were preparing for funeral, my lord, for the last rites, my lord. So under that situation, my lord, the medical doctor had gone to this spot and, my lord, conducted. So, my lord, that will not be a ground for acquittal of the accused here, my lord. I'll come to that, I'll satisfy me here.
Yes.
Yes. May I proceed, my lord? So far with regard to this postmortem report, if I take your lordship, the injuries, my lord, fracture or this one, head, my lord, what is the depth, what is there, and for that purpose, my lord, fracture of the limb, 8 ribs, these knees dissections. And as per PW 3 and 4, it has been taken, my lord, postmortem has been done in the CHE, health center, where it has been admitted by the person concerned. That it's been done at residence. It cannot be, my lord. It's a height of, my lord, illegality, my lord. They say other way to submit before this court. This is nothing but an absurd, my lord. And, my lord, coming to PW 7, my lord, will kindly see SICS SILA.
The pay, sir?
50, my lord.
50.
Yes. I have received someone to depose in the court. I joined my service in the year 1980. In the year 2012, I was posted as so-and-so. 5/4/2012, I received the case diary number 1, 2, 3, which is handed over to me by CI so-and-so with an endorsement to investigate the case being registered by previous OC. After I received the CD, I found that some action has been taken by the previous IO, but the culprit had not been arrested. I have learned that some action has been taken by the OC so-and-so as the FIR was submitted at so-and-so, but the jurisdiction of the PO falls under so-and-so. So the CDs from the OC so-and-so will be called after action taken by him. After I noted the CD, I left along with my staff to so-and-so to Brewar area for searching the suspected culprits. On reaching at Brewar area, a confidential inquiry was made by me to arrest the suspected accused person, which was learned that the suspect by the name of Tom was running a tea stall at said area, but the culprit could not be traced out. On 10/10/2012, I received a CD from so-and-so. After going through the CD, the said officer had visited the place of occurrence at Brewar and examined some witnesses, and also it was found in the CD the said officer had inquested the dead body of the victim so-and-so. In the CD, it was also shown the said officer had strongly suspected Tom so-and-so of so-and-so of so-and-so, along with surrendered essentially cadre are responsible for the crime. As I transferred some so-and-so handed over the new OC so-and-so for making further action, a cross-examination. It is true, everything I stated today is as per investigation of previous so-and-so. That's all, nothing. No, he has not done anything with regard to investigation. To his investigation, previously all witnesses' statements were recorded, my lord. Because 5/4/2012, my lord, he received the case diary. Now, next witness is PW 8, my lord. Koresh Suklain. I have received the summon code. I do not know anything about this case. I do not know the accused or the victim of this case. I do not know how I have made a witness. I have never examined by the police in this case. There is no 161 statement. Decline. Next is very important, my lord, PW 9. Page 52. Chat Silla. I received someone to depose in the court today. I joined in service as a police inspector in the year 1978, and in the year 2000 I posted as so-and-so. I received the FIR at so-and-so police station on 14/2/2012 and registered the case so-and-so 302/34. I took up the investigation till 14/2/2012, my lord. The statement of the witnesses with regard to the informants, two informant, and other witnesses all examined. I took up the investigation of the case. During the time, I received an FIR from complainant so-and-so, 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 both of so-and-so. The case was registered of an unknown accused person, my lord, on 31/12. Unknown accused person. At that time, the deceased person in this case was so-and-so. I accordingly examined the complaint as well as witnesses under section 161. However, I received the transfer order so-and-so. So he recorded the statement of these two informant on 14/2 and thereafter, till that day, the accused appellant name was not there. And in the FIR, it was unknown person on 31/12. Now, the cross-examination part is very important. I did not visit the place of occurrence after I took up the investigation. I examined 4 witnesses, including the complainant. Out of 4 witnesses that I have examined, there is no eyewitness whom I have examined. My lord, till then, on 14/2 and thereafter, till he is transferred to any other, my lord, district. Now, he examined 4 witnesses, including 2 informants. They never disclosed with regard to this particular person's name. My lord, next at page 53, my lord, PW 9. Another IO, Chuck Silla. Again examined, my lord, I'm sorry. It is again examined, my lord. Yes, yes. Cross-examination by the accused, my lord. I take your lordship to find, my lord. I never visited the place of occurrence. I have examined the complainant and 2 witnesses, the independent witnesses. None of the witnesses whom I have examined said anything incriminating against Niederman Sule, the appellant. Another accused person, my lord. Nobody said anything, my lord. While during my investigation of the case, I have not seized anything. I do not agree to the suggestion that I have not properly investigated the case, my lord. Now, for the 161 statement at the inception itself with regard to informant, I have appreciated it, not whispered with regard to appellant. PW 10, my lord, at page 54. Inspector M. Nimbo. I have received summons to depose in court today. I joined my service in the year 18. I cannot exactly remember whether it was 2012 or 13 at Saipung as OC. This case was handed over to me by SI so-and-so. He was OC at so-and-so. On 21/11/2012, I received the case. I started the investigation. On 28/12/2012, I, along with my senior officer, went to Brewer for law and order duty. And there is so many illegal camps being set up and selling illegal liquor at Brewer. During duty was 2 persons, namely Thombol, Sadar, and so-and-so, one of the accused appellant, my lord, were running the cinema hall and ration shop at the time of Brewer, and they were picked up and brought to so-and-so, and after explaining the ground of arrest to the accused persons in connection with this case, and they were arrested. Am I clear, my lord? They were never been in the part of this. They were arrested in connection with some other cases, brought to police station and implicated in this case. Admitted facts in the CIF itself. In connection with running with a cinema hall and ration shop. Now, my lord, I prayed before Honorable to remand the accused person to police custody to interrogate them, which was allowed for 7 days police custody for interrogation. The interrogation, Sri Thomas so-and-so, Sri so-and-so, so-and-so stated on the date of occurrence, war of words arise between the deceased and the victim. These are with regard to, my lord, during police custody, 7 days, held by section 25 of the Indian Evidence Act. Inadmissible evidence before the police. Then I confess, my lord. I stopped here for a moment, my lord. I commit a crime. I confess before the police. And making a confession is an exception to the general rule so far with regard to constitutional provisions. Article 22. Nobody shall be compelled to be a witness against himself. Now, if I am so, am I forwarded for recording my 164 statement, my lord? If that is so, I repented whatever I have done. That repentance, I have voluntarily said everything to him. the investigating officer. A duty is cast upon the investigating officer to forward it to the court. Thereafter, the court will give him reasonable doubt to think about it, send him to jail, so that there is no coercion, threat, inducement or otherwise to influence his mind. Nothing is there, my lord. He talks about, my lord, before the police, that accused has stated so and so. Inadmissible, my lord. And even the Supreme Court went to that extent. Anything said or done by a person before or after the occurrence, my lord, even that becomes inadmissible hit by Article 22. And here he is in police custody, my lord. So this part 7, my lord, is inadmissible, section 25 Pacific bar. The statement of so-and-so, 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 so-and-so was recorded where he stated on 21/12. These are with regard to, my lord, 161 statement he is saying, my lord. These are inadmissible, my lord. At 9, my lord, I take your lordship, my lord. On 29/7/2015, I charge-sheeted the case. Yes.
Yes, 161 you are quoting, citing him only for the purpose of contradictions.
My lord.
Yes.
No, not actually, my lord, contradictions. I am talking about the evidentiary value of that part of evidence, which the IO has recorded during interrogations of this accused person. These are whether admissible evidence. Admission part is, my lord, has to be there, my lord.
Not admissible.
This is inadmissible.
161 is not admissible.
Absolutely, my lord. That's been, I think, section 25 is the part. Even a judicial confession made before the police.
If you read 162, it's very clear.
Absolutely, absolutely, my lord, clear, my lord. Clarity is there. $25 to do. Yeah, 162. No inducement to be offered. 22. One statement to police not to be signed. And 162 so far, this one, my lord. Admissibility, confession to police officer not to be proved.
Yes, yes.
26, confession by accused while in custody of police not to be proved against him. So these are specific bar under the Indian Evidence Act, my lord.
See, we'll be using 161 for the purpose of contradiction.
Yes.
Examining the
Previous statement.
yes.
Cross-examination part, my lord, will kindly see I have marked only one line. That is 2. I did not examine any witnesses in the instant case. That's the end. Before filing of the charge sheet. PW 10, my lord, page 56, my lord, will kindly appreciate that. Another cross, my lord. Another accused, this cross has been.
See, by referring to this evidence, what is that you wanted?
I wanted that.
I mean, what is it?
That the appreciation and reappreciation with regard to evidence is with regard to, my lord, 161 statements, which are inadmissible.
Appreciation?
And reappreciation of evidence. Appreciation in trial stage or in appellate stage or in revisional stage or whatever stage it is. Evidence has to appreciate which are admissible evidence, not inadmissible evidence.
Appreciation and reappreciation of admissible evidence.
Yes. So 161 is part of contradictions, my lord, whatever he states before the court. And for that purpose, my lord, 145 and 154 of the evidence that comes into. Contradictions with regard to whichever is there, whatever it is not there, 154. Now with regard to this, the law that has been governing this particular field, the manner in which it has to be proved is Tahsildar Singh's case. 1959 Supreme Court 1020, I'll make it before this honorable court. This procedure has been given way back.
Yes.
Now, page 56, my lord, with regard to this particular other accused person, I have nothing to say, my lord. Page 57, my lord, will kindly see another, my lord, police officers comes in before the court. Page 57, his name is retired SI so-and-so Pala. I have received summons to depose in the court today. In the year 2000, I was at so-and-so. On 31/12/2011, I received a reliable information that 1. so-and-so village was murdered by unknown persons. He registered a case, he investigates at first point of time. Unknown persons at a place of burial, and the dead body was still lying at the place of occurrence. Kindly see, my lord, at the place of occurrence. So at 9:20 a.m., myself along with my staff left for spot inquiry about the incident. The matter was recorded at GD entry number 610, dated 31/12/2011. On arrival at the place of occurrence with my staff, found that dead body was lying in a pool of blood. Can you imagine, my lord? He does inquest on the dead body at the place of occurrence. As for informant's evidence, my lord, the dead body was missing. It has been taken to somewhere else. And he makes his... These are nothing, my lord. This has been a attempt been made for conviction of an innocent person. Nothing else. 31/12, I received a reliable source, so-and-so, my lord, was murdered by unknown persons at a place so-and-so. Dead body was still lying at place of occurrence. So at 9:20 a.m., myself along with myself left for spot inquiry about the incident. The matter was recorded with so-and-so GD entry. On arrival at the place of occurrence with my staff, that body was lying in a pool of blood. After observation, I held inquest over the dead body of the deceased, so-and-so, which was identified by his relative. So he conducted post-mortem on 31/12, my lord. If it is morning hours he went, then it will be 30/12. You know, my lord, he recorded in Kelmati G8 on 31/12/2011. The DD entry, he thereafter came to the place of occurrence, my lord, thereafter 31/12 he place of occurrence, and he found the dead body, and 31/12, my lord, 30/12 body is disposed of as per prosecution witnesses. Can we read it, my lord? The matter was recorded at so-and-so GD entry 31/12/2011. On arrival at the place of occurrence with my staff, found the dead body was lying in a pool of blood. Body has been taken to the house at 38, as per prosecution witnesses. After observation, I held inquest over the dead body of the deceased so-and-so, which was identified by his relatives. Can you imagine, Mama? And the dead body was, wherever it is, my lord, it's been arrested, it's been there. After it's been taken to house, my lord, he finds the dead body in plural blood. At place of occurrence, after, my lord, 29, 30, 31, 2 days. The inquest report, my lord, he exhibits. Exhibit 4.2 is my signature thereon. These are all incorrect documents. I am not using the word false document being prepared. I am refraining myself. These are all creations. And this can be created, my lord, at any point of time, police, by floating the jail manual, police manual and everything. This is the standard of proof wherein a person has been for life in prison. Now, my lord, cross-examination part, my lord, same thing, nothing as such, my lord. Yes. Yes, last part at page 58, my lord will kindly see. After examining the 3 witnesses, nothing incriminatory was said about the accused Thomas, so-and-so, so-and-so. Am I clear, sir? He proved the contradiction with regard to previous statements, informant, 2 informants also. Whole case demolished. Of the last cross-examination part, after examining the 3 witnesses, nothing incriminating was found about accused Humbert, the appellant. The informant doesn't name him, my lord. None of the IO, my lord, PW7, PW9, 10, 11, stated about recording of the statement of these 2 eyewitnesses by these witnesses. Am I clear, my lord? None of the witnesses. With regard to the so-called, my lord, eyewitness PW1, 2, nobody says with regard to statement being recorded by PW7, 9, 10, 11. They were forwarded to the court of law for recording 164. No witness says. Their 164 has been recorded, my lord. This is the quality of the evidence, my lord, on the basis of which, my lord, I have been behind the bar, my lord. And the judgment, my lord, I'll take your lordship to the judgment and the publicity of the judgment, my lord. RTI. Which one you are talking about? Which one? Which? RTI. 108. 108, my lord. My colleague has been insisting me to take this honorable court with regard to pointing out dangerous thing, my lord, with regard to the information gathered under RTI Act, my lord, 108. I'm reading it. GD entry number date. I, along with accompanying staff, retired so in cause of inquiry, found it on 29/12. She saw friends, is about so-and-so, was having drunk liquor with one Sri so-and-so, other at the place called Brewer under so-and-so Ilaka at about 9:30 p.m. There was a quarrel among them, who later Sawas was assaulted by dangerous weapon there by inflicting serious injury and died at the spot, and checked the dead body of Sri so-and-so, found and miscreants had smashed his head, seems by wood on the backside of his head, found broken. His forehead and checked so-and-so, so-and-so, so-and-so. This is the thing. And my name is missing. There is another name is been cropping up. The first date. On the first day, 31/12, my lord. No investigation on this. This is been brought by way of RTI, my lord, informations. He has been assaulted by someone else in a drunkard condition. And postmortem, my lord, my learned colleague has been trying to justify a postmortem at residence, wherein they will do alcohol tests, they will do blood tests, my lord. They will do viscera tests, my lord. This is, my lord, extreme, my lord.
Yes.
Yes. My lord, 313 statement is very important, my lord. Otherwise, my lord, earlier, my lord, the law was different. Now its law is different. Whatever explanation given by the accused person during 313 statement, the Honorable Court has to take it seriously and discuss in the judgment itself that why this has been rejected, reasons behind it on writing. Page 79, my lord, will kindly see. That is a thumb for my client, my lord, appellant. Everything has been stated, my lord, here. Do you have anything to say with regard to this? In my life, I have never beaten anybody, nor I have ever gone to Brewer. This is the evidence. In 313, my lord. Page 79. Every answer, my lord, has been denied. Any link with regard to, my lord, the commission of the kind has been denied.
This is a 313 statement.
Yes. Now, his denial is never been discussed with regard to evidence in the judgment itself. And that itself makes it, my lord, perverse. My lord, at page 84, kindly see your 84, my lord, will kindly come to 84. This 313 part, my lord, it's containing question number 18, if I take your lordship. Do you have anything to say?
No, sir.
84 page, my lord.
84.
Yes, my lord. Last question with regard to, my lord, second last question with regard to, my lord, 313. The police have kept me in so-and-so police station for around 13 to 14 days without any interrogation, just because I am poor and all at home are sad, and thereafter I was taken to jail. I am an orphan and I have a family to look after, and I was looked down by the police who falsely alleged against me. I have never beat any, I am innocent. And in custody, my lord, 13 to 14 days.
Yes.
Now, my lord, next is coming the judgment, my lord. In the judgment, I take, my lord, no, whole of the judgment, I will not disturb this honorable court, my lord. Paragraph 17, my lord, will kindly see. In reply, learned PP sponsors, whatever it is.
One minute, sir.
Yes, page 90. Judgment starts from, my lord, page 85, my lord. With regard to the evidentiary value of PW1 and 2 eyewitnesses who were recorded after 65 days. In reply to learned PP, that exhibit P2 is just bone without flesh. She submitted that the statement of PW1 and 2 recorded by magistrates was recorded on oath and signed and hence relied on to under section 80 of the Indian Evidence Act so as to whether such statement can be considered as genuine. This was a submission that was been made, my lord. And the question with regard to that under what circumstances for 65 days they were mum? There are no discussions. Are we at that question, no? Page 44. Page? Page 97. 97, my lord. Can you come to page 90? 95, my lord, first. 95, paragraph 40, my lord. Why PW1 and PW2 evidence has been taken for corroboration, my lord? The reasons, my lord. Even though it was argued by the defense in the affair it was given unknown person, PW1 stated in his evidence she was informed by her inquiry from PW1 and 2 on that night when they came to inform her that it was Tom who has murdered her deceased son. However, PW1 in her evidence at point number 4, she also stated she does not know about the details of Tom's identity. Besides, PW1 and PW2 also know him by name and in person and not proper details, which reason may be made the mother and the wife not sure. Can you believe this, my lord? Can this be accepted, my lord? Wherein in 161 a person has been informing, my lord. Here, my lord, PW3 and PW4 happens to be an exception to the general rule of hearsay evidence. Why? Because PW3 and PW4 came to know from PW1 and PW2. So, things said or done by a witness before or after an occurrence is a relevant fact. Whether that relevant fact is been part of the affair, no. Whether that relevant fact is part of 161 statement of PW3 and 4, no. And the reasoning given in that particular is not been known. Now, my lord, will kindly come to page 97. This court is opinion, since the evidence or witness. Yes. 97, my lord. Here, no? I take your paragraph 44, my lord. I will not read the upper portion, my lord. I come to, my lord, in between, my lord, will kindly see right corner, however this, first, second, third, fourth, fifth, sixth, 7, 8, 9, 10, 11, 12, 14th line, my lord.
However, this court is opinion.
Yes. Court is opinion that since in the evidence of PW1 and 2 is apparently last in theory of the accused, Tom continues hitting the deceased who was half dead or unconscious, where they did not state by what weapon they say in the fight of the incident occurred, and that during the happening and continuous hitting, they led the place of occurrence to their relays to inform the relatives of the victim. Thus, it appears the stated fight in the incident till the point of time they had seen the incident appears to be not with weapon, but with physical body of accused. And the weapon as opined by PW6 in his postmortem report at exhibit must have been used when PW1 and PW2 had left the place of occurrence at Brewer. Am I clear? Assumption, my lord. It's an assumption, presumption in the case of 302. It ought to be in the case of 304 part B, I understand, POXO, I understand. Where is the question unless there is evidence? These are perverse findings on the basis of which, my lord, I am praying with folded hands before the honorable court for acquittal of this court of dear prosecutor judgments. My lord, postmortem report, can you see one? 74. Of our paper book, my lord, of our petition itself, no?
Paper book, paper book.
Paper book, yes. Paper book 74, my lord. The wound. After 2 days, my lord. External appearance. Condition, subject, stored, so and so, decomposed, etc. Fresh. Page 74 of the postmortem report. No rigor mortis, my lord. And this is, my lord, with regard to, my lord, a finding being arrived at by an expert who has committed postmortem at residence. Now, my lord, coming to the law, my lord, post-propitiation, I have prepared, my lord, certain judgments with regard to this. My lord, will kindly take up this. 2 volumes. The first judgment at page, my lord, page number 9. First judgment to given page. 1. Page number 1, my lord. Famous Kaliram's case, my lord. 3 judges judgment, my lord. Straightway, my lord, without wasting the valuable time of the court, paragraph 14. Yes. What is the evidentiary value of a person whose statement has been recorded after 2 months? The case of the prosecution is that the injuries of so-and-so deceased was caused by the accused. The accused has, however, denied this allegation. In order to bring the charge home to the accused, the prosecution laid evidence on a number of points. The High Court accepted the prosecution allegations in respect of the based in conclusion upon the following pieces of evidence. The evidence of paramour none, that the accused had stayed with him on September 29, 1968, and that on the evening on that day proceeded towards the house of so-and-so deceased after he had been shown the way by paramour none. The confession of the accused contained in a letter dated so-and-so. The extrajudicial confession made by the accused to so-and-so. We may first deal with the deposition of paramour none, PW 14. The deposition consists of 3 parts. The first part relates to the stay of the accused with paramour none at his shop in village so-and-so on September 28 and 29, 1968, when some fish and liquor are stated to have been taken by the accused and paramour none. This part of the deposition relates to an innocuous circumstances and hardly connects the accused with the crime. The second part of the deposition is to affect that the accused on the evening of September 29, 1968 told paramour none that he had to go to the house of Dianu, who is a deceased, my lord, and that paramour none showed at the instant of the accused the way which leads to the house of Dianu at a distance of 3 to 4 miles from the shop of paramour none. We find it difficult to accept this part of deposition of paramour none. Paramour none admits that he came to know about the murder of Dianu and Nanti about 4 days after those persons were found to have been murdered. It would therefore follow that paramour none came to know that the murder of so-and-so on or about October 4, 1968. Had the accused left the house of the so-and-so deceased on the evening of September 29 and had paramour none come to know that their so-and-so was murdered in their house, these facts must have aroused the suspicion of paramour none regarding the complicity of the accused. Paramour none, however, kept quiet in the manner and did not talk of it. The statement of paramour none was recorded by the police on December 11, 1968. If a witness professed to know about the gravely incriminating circumstances against the accused of the offence of murder, and the witness kept silent for over 2 months regarding the said incriminating circumstances against the accused, his statement relating to the incriminating circumstances in the absence of any cogent reasons is bound to lose most of its value. Am I clear, my lord?
So according to you, in view of there's 65 days,
Absolutely, absolutely.
In the light of the judgment,
Yes.
the benefit should go to the accused. That's your argument.
That's my argument. Next judgment, my lord, will kindly come to page 15. This is recent judgment on the same principle, my lord.
Yes.
Which has been laid by 3 judges, my lord. Paragraph 23 and 4. This is a judgment of our High Court, my lord, Guwahati High Court, Rishikesh Roy, Justice Rishikesh Roy, my lord. Page 23 and 24, paragraph 23 and 24. Relying on this judgment itself, my lord. Paragraph 23 and 24.
Paragraph 23.
23 and 24, my lord. 23 at page 24 it starts.
1 minute. At page 24.
Yes. Last paragraph, my lord. First one, my lord. Insofar PW2 is concerned, admittedly he is not listed as a witness in the police report or sheet. He gave statement to police on an affidavit for the first time on 18/2/2002. That is the date when the police report was prepared. This implies that he remained silent for a long time, as 3.5 months. In Kaliram Prasad, Himachal, 3 judges, this has been discussed, my lord, and ultimately benefit has been given to the accused persons, my lord. The next judgment I rely on, my lord, that here, my lord, I have been arrested, taken into police custody as for record is 7 days. No TIP, nothing. If this is the person, my lord, a duty has been cast on the investigating officer. And till, my lord, my custody was there, my name was as an accused was not there. And I have been arrested, I have been put before the honorable court and sought police custody, 7 days, no TIP, nothing. And in absence of TIP, my lord, and even my title is not been known as per the PW1 and 2. So TIP is a must. In that circumstances, the very logic with regard to introduction of, my lord, section 9 of the Indian Evidence Act, my lord, is that one. That somebody commits doggedly at my place, my lord, I see his face. I don't know him as such. So in that circumstance, he should not be exposed to anyone. He should be taken to jail for TIP, my lord, first thing first all, identity. It's not been there, my lord. And here, my lord, I take your lordship to
Yes.
yes. Page 28, this is the judgment with regard to this, my lord. Karmajit Singh, alias Papu, my lord. Relevant para, my lord, I will not read it, my lord. Page 28, relevant para is para 6, my lord. 6. What is the requirement of, my lord, TIP has been laid down, and that's the requirement, my lord. Nothing been done here in this case. And in the court, my lord, for the first time, my lord, is identification. For the first time in the court, by an witness identifying an accused person is no identification in the eye of law, my lord. Now, next judgment, I place it before the honorable court. My lord.
In fact, I was asking your brother about the same question.
Yes.
You know, you're addressing.
Yes. Yes. My lord, next judgment 2019 4 SCC, that is a page 33, my lord. You can see. 33. Yes. It will keep principle of Russell. Huh? Yes. This is not naming in the affair, in spite of knowing the assailants. What is the evidentiary value of it? And relevant para is 7 to 11, my lord. That is the same principle with regard to
7 to
11.
Yes.
And that has to be disvalid, my lord. This is afterthought, my lord. These are all principles of law, my lord. wherein, my lord, on the basis of records, we argue, my lord. One of the accused persons, my lord, name was not mentioned in the affair, even in spite of knowing it. And thereafter, my lord, he was brought in, my lord. It was never stated in 161 as well as in affair. Then the evidentiary value, it cannot be accepted, my lord.
Proceedings. 19, 19. This is against this. You can call anybody. You can add person 319, which you can add. Yes.
Yes, next judgment, my lord, with regard to 313 statement, my lord. That is, my lord, page, it starts from page 37, my lord. Relevant para is 19 and 20. And this has been a judgment of 2019, my lord. Reported.
There are 19 and 20, page number 37.
Yes, page number 43 it will be. May I read it, my lord? Section 313 CRPC cannot be seen simply as a part of odi ultem partem. It confers a valuable right upon an accused to establish his innocence and will be considered beyond a statutory right as a constitutional right to a fair trial under Article 21 of the Constitution. Even it is not to be considered as a piece of substantive evidence, not being on oath under Section 3132 CRPC. The importance of this right has been considered time and again by this court, but it yet remains to be applied in practice as well as see presently in discussion to follow. If the accused take a defense after the prosecution evidence is closed under Section 3131B CRPC, court is duty bound under Section 3134 to consider the same. the mere use of the word may cannot be held to confer a discretionary power on the court to consider or not to consider such defense, since it constitutes a valuable right of an accused for access to justice and the likelihood of the prejudice that may be caused thereby. Whether the defense is acceptable or not, and whether it is compatible or incompatible with the evidence available, is an entirely defined matter. If my lord, there has been no consideration at all of the defense taken under section 313 CRPC in the given facts of a case, the conviction may well stand vitiated. To our mind, a solemn duty is cast on the court in dispensation justice to adequately consider the defense of the accused taken under section 313 CRPC and to either accept or reject the same for reasons specified in writing. It's not been done in this case. And in our High Court also, my lord, in trial court in Assam, not been followed in that manner.
Yes.
And the next judgment, my lord, is regard to, my lord, page 45, my lord, will kindly 3, my lord. In our High Court, to meet these exigencies, my lord, in criminal appeal nowadays, my lord, wherein it's a case of, my lord, serious offences more than 10 years, now amicus curiae are appointed, my lord. And the requirement with regard to Guwahati High Court is this, my lord, that has to be a designated senior in case of death sentence also. And in trial court also, our High Court has passed circulars and all this thing. My lord, the mode in which the amicus curiae are appointed, my lord, because sometimes, my lord, the amicus curiae, the way of cross-examining everything, my lord, even defending a person, put a person behind the bar. It happens. Here in this case, my lord, page 45, here, my lord, it's a case of death sentence. Supreme Court interfered with because it was an amicus curiae, my lord, wherein, my lord, this is decided on 13/10/2022, my lord. And the relevant para, my lord, I am reading it, my lord. Page 81. Big judgment, my lord.
Yes.
Yes, my lord.
117.
117, my lord. Before parting with the case, we'd like to place on record an observation of our touching and important aspect of the case. Without any hesitation and with this disappointment, we state that the case on hand is one of the most perfunctory investigation. It appears that the accused therein was provided with a legal aid. He might not have been able to afford a good and experienced trial side lawyer to defend himself. We have noticed that the cross-examination on each and every witness is below average. Question which the defense counsel was not supposed to put to the prosecution to put without realizing or understanding the legal implication of the answer to such questions, more particularly when they were not necessary. The defense counsel remained oblivious of the position of law that suggestion made to the witnesses by the defense, the answer to those are binding to the accused, my lord. Ultimately, my lord, it has been, my lord, remand back question again. The judgment was set aside, my lord. Last question, my lord. Yes. The result happens were allowed. The conviction of accuser 30 Indian Palace set aside. He is acquitted of the charge framed against me, he shall be at liberty at will. As because, my lord, an incompetent lawyer, my lord, is being allowed to be appointed as amicus curiae and conduct the trial. And that too for an offence wherein, my lord, now the interpretation with regard to 302 life sentence is still life, my lord. Unless he gets, my lord, benefit under the jail manual, my lord, 433A remissions and all. Previously, it was, my lord, 51 or 54 of the Indian Penal Code is there. Fraction of term of punishment is to be reckoned as 20 years. So it was taken as 20 years. The first Supreme Court judgment came in with regard to this, and it's been stated that 51 was not discussed. 51 or 54, so IPC. It was not discussed. Subsequently, it was pointed out, my lord, that time we were on the way to Shillong Court for a case, my lord. Then very senior lawyer of ours, my lord, who was an asset for us, we always learned, Nilay Dutta. He's been a very profound lawyer, my lord, fantastic in every field, my lord. And so, like, we are discussing about the Supreme Court judgment, in the way I pointed out that why in this judgment this provision was not been discussed. 54, my lord. In every case in which sentence of, my lord, fraction of terms of 57, in calculating fraction of term of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. 57. It was never been discussed in the first judgment. Then, my lord, with regard to Siddharth Rutra, very fine lawyer in Supreme Court, my lord, and he's been appointed in many cases as amicus curiae for assisting the court, he pointed out. And in the last judgment, my lord, it has come to, my lord, fraction punishment 20 years, 20 years, 20 years, till he dies. But the 433 remains. And the last judgment, my lord, with regard to, my lord, Tahsildar Singh's case, that starts at 87, my lord. We don't follow it, my lord. Here also it's not been followed, my lord. And the relevant paragraph, my lords, are, my lord, 26 and 27. How contradictions are required to be proved. Page 104, my lord.
Yes.
26, my lord, from the foregoing discussion, the following proposition emerged. A statement in writing made by a witness before the police in the course of inquiry can be used only to contradict the statement in the witness box and for no other purpose. Statements not reduced in writing by the police officer cannot be used for contradiction. Though a particular statement is not expressly recorded, a statement that can be deemed to be part of expressly recorded can be used for contradiction, not because it is omission strictly so-called, but because it is deemed to be from part of the recorded statement. Such a fiction is permissible by construction only in the following three cases. When a recital is necessary implied from the recital or recitals found in the statement. Illustrations in the recorded statement before the police, the witness states that he saw A stabbing B at the particular point of time, but in the witness box he saw A and C stabbing B at the same point of time. In the statement before police, the word only can be implied. The witness saw A only stabbing B. A negative aspect of positive recital in a statement illustration in the recorded statement before the police, the witness says that a dark man stabbed B. But in the witness box, he says a fair man stabbed B. The earlier statement must be deemed to contain a recital not only that the culprit was a dark complexioned man, but also that he was not of fair complexion. And three, when the statement before police and that before the court.
This will not be applicable because according to there is no eyewitness at all.
No eyewitness at all. It's a case wherein, my lord.
It's a case where the person said they stabbed this side, that's a A stabbed B, like that.
Yes.
But it was stated to be an eyewitness. But in your case, there is no eyewitness at all, is your case.
Here it's there appears to be all of a sudden two eyewitnesses were created. That too after 65 days of, my lord, registration of the case. And that too their statement doesn't reconcile together. 161, 164, and the statement, substantive evidence before the court. And their statement is not been on material particulars, is not been, my lord, supported by even the eyewitnesses, my lord. Whole prosecution case appears to be stage managed. Because on 31/12, GD entry has been made, which I brought through RTI application, accused was different. On 31/12, inquest has been done. But this particular witnesses, PW 3 and 4, witness has been done on the next date, 30/12.
Yes.
Crime weapon is not there. It's okay. That's my respectful submission.
Yes.
Thank you.
My lord, in order to. Another division. Shall we take up your argument next week?
My lord, I leave it to your lordship, my lord.
In the meantime, next week, we'll fix a date. 14th.
Really, sir?
It's a flight is at 3:30. 3:30, then we have to leave around 11 o'clock. Free week commencing 18th?
On 18. On 18.
20?
On 18. On
18th, it's available.
My lord, may I pray for accommodating me on 18 because I have a matter in Dhubri court, my lord. It's far away from Guwahati, my lord. 8 hours from Guwahati. The trial matter, my lord.
So you don't want on 18th?
18, my lord. Any day, my lord, in April first week, my lord. Like 1st April, my lord.
April 1st.
First, my lord. Deeply organized.
We are reopening on April 1st.
My lord. Deeply organized.
Deeply organized. First. The arguments of the appellant is concluded for the for the submission of the respondent. State posts the matter on 1st April.
1st April. Deeply obliged, my lord. Deeply obliged.
On the list, item number 1.
Here there was a delay and your lordship had directed us to take steps on the private respondent. We've taken steps, delays of 3 days, my lords.
Appeared. The respondent has appeared. The private respondent is not here, Your Lordship.
I was informed.
But in fact, I think I'm the main respondent here. Main contestant. Where is the private respondent? Notice has been served, name has been printed.
Nitish, notice is served, my lords. We've taken steps on the private respondent. I was under the impression Mr. Mosika would be
We are all aware, in fact.
Yeah, well, actually, he's.
One minute. 4523. Who is appearing with the private respondent name?
Well, it's before in the earlier round of litigation, before the single judge was Mr. Mosika, my lords.
Mr.
Mosika, Nitish Mosika, my lords.
His name is not printed here.
My lords.
Please, Your Lordship. Lordship, I was the writ petitioner before the single judge.
Yes.
He's the private respondent here, my lords.
Delay.
We have received the papers, Your Lordship. Paper book, we have received the appeal.
Yes. With regard to delay of how many days?
3 days.
3 days delay.
We have no objection.
The respondent have no objection for the delay being condoned. Condone the registry is director number the appeal and list it for hearing next week. Yes.
Lords, may I only pray if the matter comes up week thereafter, my lords.
1 week.
1 week after a week. It's not inconvenient.
Commencing 18th. 18th.
Obliged.
Item number 2. Yeah.
Item 2. Who is appearing? Notice has been served. How many days delay?
Notice has not been served. Notice has not been served. Notice has not been served.
No representation. Last time itself, we pointed out section 75G.
Yes.
Asked them to read the papers and come. No representation for the petitioner. What's the matter for dismissal on 18th?
I wanted to say something. Court's permission. There's some Lordship in the code number 2, 3, and 4. This side we have this petitioner always this side, but here is wrong.
So you change accordingly because initially when they came here, see in Chennai, Madras High Court, the stenographer will be on the left hand side.
Yes.
The clock will be in this side. So whenever I know anything, I see turn this side.
Yes.
The practice. Here is everything on the right hand side.
And especially now,
the court officer will be on the left hand side there.
Can we bring a change, Lordship? So especially here.
Whichever convenient you do it.
This is a petitioner side, appellant side.
Whatever it is. Initially when Madurai High Court was constituted,
yes, yeah.
they used to have placard saying that petitioner respondent. At the time it was not so crowded. Now it is crowded. The advocate, the counsel are arguing. Here at least I'm very happy to see the first 2 rows are kept vacant so that the counsel can come forward and address the argument. There it will be crowded.
Dear Lordship. Let's see, Your Lordship. Now, let's see from tomorrow, it depends on the registry.
Whatever, it's not convenient for us. It is not a problem at
It's
all.
more convenient to be this side, Your Lordship. Sometimes it does a ulta lagta, so.
Merely because you are going to stand on your right hand side doesn't mean that you are right.
That's true.
Yes.
Much love.
Yes.
Wait, please. But,
Yes, sir.
Lord, all I'm praying for in this matter is, my lord, to be compensated, my lord, for wrongful, my lord, termination between the year 2015 and 2018. I was on temporary, I was on...
Yes, last time the matter came.
Yes, my lord, yes. So that is my only prayer, my lord, and it's up to your lordships, my lord.
1 minute. I think it's a different case, huh? What is this? Today is 6-3. Today is not 6-3, no? Oh, they have given the supplement list. Notice will have to go. We ask them to list it tomorrow. It doesn't matter. Transfer petition. You are appearing in transfer petition.
No, my lord.
I am appearing in the transfer petition as respondent.
Where's the petition? The parties will have to be appeared, no?
No, I think there is.
The judge has refused to take up the matter.
Yes, Lordship. There are 2 supplementary.
Who are all the parties? Let them appear, then we'll transfer the matter. 18th.
Lordship, the judge in the lower court, Lordship, has recused the matter because she has signed the wakalatnama.
Yes.
So, Lordship, it as per your Lordship means that whatever Lordship your endorsed it to any other court might be in East Khasi Hills because the matter is in
Who are all appearing? You are appearing on the other side?
The other side, the collector is for the respondent to know. The petitioner side is Mr. Kind.
This is with regard to compensation, is it not?
Compensation, Lordship.
So you have no objection? Which court you want to?
It may be in East Khasi Hills, Lordship, because it may be in East Khasi Hills, Lordship.
The petitioner comes.
It may be in East Khasi Hills district, Lordship. I am not.
No, applicant is not here.
Complainant, Lordship, complainant, the claimant counsel is Mr. Kind, but due to his ill health, he is not appearing, and his junior in the lower court, his junior appeared. Here, since the matter is a transfer matter, has come up before this High Court, so the judge from the Ribhoi district cannot take up.
Correct.
So it may be transferred to East Khasi Hills district.
But let the other person also appear. Let the junior also appear through online. We'll give a date, then we'll transfer the matter. We'll call the matter on 18th. Call the matter on 18th. Then we'll post it before some other court. Not a problem.
Lordship.
Yes. Notice. Court notice given to the petitioner. You are appealing for the respondent.
I am for the respondent number 2 and
I'll be for number 1, the collector report is
How many respondents are here?
2.
two respondents.
So you are appealing for both respondents.
For one.
Both respondents are present. Court notice to the petitioner, returnable by 18th. Respondents are permitted to inform the counsel who has appeared for the petitioner herein before the Sessions Court.
Lordship.
You inform the district court, is it not?
Lordship.
District court. You inform them about the date of hearing and disk number.
Lordship.
Yes.
On the main supplementary, item number 1.
Apologies, my lord. My lord, I was not aware of the other supplementary list. Apologies. Apologies, my lord. I was not.
No, not a problem at all. No problem.
So, my lord, the limited prayer, what I'm praying today is, my lord, for my wrongful termination, my lord, which was stigmatic. I'm claiming for compensation between the year 2015, from when I was terminated, till 2018, when I've been re-employed, my lord.
Reinstated.
Re-employed, my lord, somewhere else.
Re-employed somewhere?
Yes, my lord.
Yes.
So, my lord, that is the only point, my lord.
3.
Yes,
so,
my lord.
unless the order of termination is set aside, how will you entitle to back wages?
Yes, my lord. The prayer is there, my lord. The prayer is there. What had happened is, my lord, when I was in work charge employment, my lord, I was not permitted to sit in an exam for regularization of my services, my lord, on the grounds saying that my degree is fake. Immediately, within a month's time, my lord, I was terminated, and the termination was not simpliciter, my lord. And that will be clear from the affidavit filed by them, saying that my initial appointment itself is on fake documents. Then I filed this writ petition.
So the termination causes stigma on you?
Yes, my lord.
Yes.
Yes. I filed this writ petition, my lord. During the course of this writ petition, the matter went to the Lok Adalat. So what they did is, my lord, ascertain from the institute from where I obtained my degree, and it has been confirmed that their degree are proper. So thereafter, my lord, yes, my lord, thereafter, they again offered me for reinstatement in a temporary post, which I said, my lord, I declined, saying since I already have some employment elsewhere, you kindly compensate me. My salary was 8,000, meager 8,000, my lord. So
for 3 years.
8,000, yes, my lord. For 3 years.
8,000 per month, 3 years.
My offer, my lord, yes, my lord. I submitted an application representation, my lord, which has come by way of additional affidavit filed by them.
How much you have asked?
My lord, in this, I have asked for, my lord, it comes to around, my lord, 2,60,000. That is the principal amount, 8,000 per month. And interest, my lord. Interest is, I leave it to your lordships. But
8,000 for 3 years, it comes to 75,000.
My lord, 8,000.
Is it 3 years? 36 months.
3 years, my lord.
So, 96,000. Yes, nearly about 2 lakhs and odd. Yes, correct.
2,60,000. So that is the only point, my lord.
What is the Advocate General?
Yes, Your Lordship. Now, first thing, my lord, my friend is saying that he was appointed against work charge employment, my lord. And he was appointed against a post for work charge which he was not having the qualification, my lord. Kindly see the prayer, my lord, page 10, my lord, page 10.
So, both of you are ready?
I am ready, my lord. I am ready, my lord.
Yes.
Kindly see the prayer, my lord.
Prayer.
At page 10.
So, is it an admitted fact? Is it a fact that he has initially you have terminated the service on the ground that he has got a fake certificate?
No, my lord. If your lordship will see the termination order, it says termination simpliciter. What has happened, my lord, that he was not having the qualification for this post, my lord, and he sought regularization against the
appointment order. When did he join? When did he terminate?
Your lordship kindly see appointment order at 17, page 17, my lord.
Page number 17.
Not 7, my lord.
Page number 17.
Yes, your lordship. Kindly see. He is 17.
Page number 17. Yes.
Annexure 2, my lord. In the interest of both work. Challam MSCB is pleased to appoint the following
What is
diploma.
his name? Sri, sir, you have.
But I am at serial number. Serial number 4, my lord.
Your Lordship, kindly see the first paragraph of the order, my lord.
Both
In the interest
appoint the
of-
following a temporary charge in a lump sum of 8,000 rupees per month. They have joined appointment to temporary determined any time without any reason. The suit indicate below.
Your Lordship, this is the, and your Lordship will mark this word diploma engineer electrical, my lord. The
Diploma?
post is
Diploma?
engineer electrical. Diploma engineers electrical.
Where is that?
First line.
Where is
Pleased to appoint
in the board, please to appoint the following diploma engineers. Electrical.
electrical.
Yes.
Electrical. And your Lordship, kindly see his name is at serial number 4, my lord. And kindly see the qualification which he has placed before your Lordship. Page 15. 15, your Lordship, kindly see page 15, his qualification.
Page 15.
Yes, 1 5. And kindly see that was of 2007 and his qualification
He is a bachelor's in science.
in applied information technology. my lord.
Applied information technology. Yes.
And your Lordship will see the degree date is given. We are not going into the veracity. Having duly completed the prescribed required with C grade in the year 2011, my lord. In given under the seal of the university on 19th May 2011, my lord. So an appointment he was, and your Lordship was seen
So
at page
on
15.
the date of appointment, he did not possess any qualification.
And after that also he was not having qualification, my lord. And kindly see admission on his part, my lord. Page 31, when he has given the representation, page 31, my lord.
Yes.
Paragraph 5, my lord, this is the representation where he has, that sir, when I inquired from the esteemed department with regard to
Sir, 1 minute, sir, 1 minute.
paragraph 5 at page 31, my lord.
Oh.
That sir, when I inquired from the esteemed department with regard to non-inclusion of my name for appearing in the written test for regulation of my service, I was informed that I was appointed wrongly in the said post, and also I am not a technical engineer, as such my regulation of service cannot be considered. My lord, this was the reason for that, and then your lordship will see the termination office order at page 33. The services of so and so engaged as work charge junior engineer wide order dated 21st December 2007 and presently posted hereby stand terminated with effect from 31st October 2015 afternoon, my lord. The petitioner has already left the employment, my lord. He has been terminated. He has joined somewhere else in 2018, my lord.
That is right.
And he is not having the qualification also, my lord.
He has worked from 2007 to 2015, 8 years.
I have paid that amount, my lord. He has received the salary. There is no dispute about that. His claim is, he is saying that you give me appointment against the post of technical person when he is showing his own degree that he is not having the qualification, my lord. So kindly see. In fact, earlier also he has been given opportunity to appear and he did not qualify, my lord.
Page
21, your lordship will see. It's not that any wrongful termination has taken place, my lord. 21, page 21, the part of the writ petition, my lord.
Yes.
Subject, written test for recruitment to the post of junior engineer electronics and computer engineering in Meghalaya Energy Corporation. In response to your application of post of junior so and so, you are required to appear in written test on 24 July 2010 in so and so, my lord. And he has not passed that also, my lord. 20.
Yes,
and this is, yes, my lord, at page 29, para 3, my lord. His own admission. 29, para 3. Sir, in the year 2010, I was allowed to appear for the written test for the recruitment to the...
But kindly have their affidavit, my lord. What is their reply in their affidavit to my writ petition?
That is, you can't develop your case based on the counter. You have to argue based on your statement. You are not qualified at all to hold the post of the electrical engineering, junior engineer electrical.
The request that I had made before them is, in 2015, when my other colleagues, my lord, were permitted to sit for the exams, I was not permitted.
But you have been given a chance to write the examination, you have failed. That's all.
2010, my lord, many have failed. Now 2015, again when the exams was conducted, my name did not appear. My lord, kindly have page, my lord, page 28. Page 28 of my writ petition, my lord, an extra 9. So in the written exam in 2015, this is 19th August 2015, opportunity was granted to all the candidates, my lord. I was not permitted, my lord.
Why? How do you say you are not permitted?
My lord, that is why thereafter I made my representation at page 29, my lord. At page 29, which they have not entertained. And in the affidavit, they have said you were not permitted to sit for the exam because you were not eligible.
You are not eligible?
Yes, my lord.
Eligible to?
Because my degree is fake, my lord.
Your degree is fake?
Yes, my lord.
Where is it stated?
Kindly have, my lord. The affidavit, my lord. Affidavit, my lord, page 2. Affidavit filed by the respondent, my lord, paragraph 8. They say I don't hold a degree, my lord.
This affidavit?
The affidavit, my lord.
Joint Secretary?
Yes, my lord. This is the Joint Secretary, my lord. So they say, my lord, that the above made in paragraph so and so.
Which paragraph?
My lord, paragraph 8 at page 2, bottom.
Paragraph 8 at page number 3, yeah?
Yes, my lord. Page number 3.
Page number 2, yes.
Page number 2, bottom, my lord. That the amendments made in paragraph so and so of the writ petitions are false, incorrect, and denied. And in reply, the answering respondents submit that the other candidates who are working as junior engineer work charge were informed and directed to appear in the written interview on 26/9/2015 at so and so as they were found eligible from the academic certificates fulfilling the requirements for the post. The petitioner was not included in the said list of eligible candidates for written interview for regularization of service as he was found not eligible, for he does not possess the requisite qualification for the post of junior engineer in the year 2007. Further, the document certificate subsequently submitted by the petitioner in the year 2009 regarding this qualification are also not the valid document certificate. They say my documents are not valid. Then further they say, my lord, it is further submitted.
Document certificate subsequently submitted by petition regarding the qualification or not valid document and certificates. Yes.
Then they say, my lord, it is further submitted.
What are the documents you produced in 2009?
My lord, my degrees, my mark sheets.
Degree mark sheet are 2011.
Yes, my lord, because they were issued, the degree was issued in 2011, my lord.
But you cleared the examination in 2009.
Yes, my lord. So, my lord, it is further submitted that as per the document certificate submitted, the petitioner has not passed the advanced diploma. So, they're saying even the diploma which I'm holding, I have not passed. In software engineer in the year 2007, as such, he submitted the said documents only in the year 2009. However, the petitioner was appointed as temporary work charge junior engineer by order dated 20th December 2007 in a lump sum payment of 8,000 only per month. And thereafter, when the post of junior engineer electronics computer science was advertised on 11/8/2009 for regularization of
So
service.
you have been paid gratuity?
No, my lord.
2007 to 2015.
My lord, when I was serving, I was being paid, my lord.
No, that is salary.
Yes, salary.
Gratuity.
No, my lord, only fixed salary, my lord. Only fixed salary.
Fixed salary is different, sir. Only after cessation of employer-employer relationship only you will be entitled to gratuity.
Yes, my lord.
Why don't you pay him the gratuity alone?
Yes, my lord. I quite see what is falling below. Gratuity, I will have to, my lord, I have to come back on this issue of whether he is entitled to gratuity for, because he has served for more than 5 years. Possibly
Yes,
he will
more
be.
than 5 years you have served, and I think for about 8 years you have served. Based on rupees, you have to
Yes,
calculate
Lord.
and pay interest.
Your lordship, I will examine this aspect. There I can't argue, my lord. And then to
No, you will follow order. What is the purpose of keeping the matter? For the services, you will have to pay.
Yes, your lordship passed the order
We will
that
say that the termination is right, anyway, you have to pay, you get the compensation.
gratuity, my lord, because termination gratuity, he may be entitled in accordance with law. We will consider and pass the order, my lord, for gratuity. If he is entitled.
But gratuity, I think there will not be any separate regulation for they are governed by the Payment of Gratuity Act. Is it not?
Yes, gratuity. Yes, Your Lordship, Gratuity Act, but
Gratuity Act.
amendment also, if I'm not wrong, my Lord, there is some state
yes.
amendment. There will be some state amendment in the Gratuity Act, my Lord. That is the part I have to examine, my Lord.
Come. The present writ petition has been filed by the petitioner questioning the order of termination dated 30/10/2015 issued by the second respondent. On the ground that there is a discrimination by not allowing the petitioner to take up the written examination for regularization when other candidates have been allowed, on the ground that the degree or certificates produced by the petitioner are fake. Full stop. The petitioner has joined the services of the respondent corporation by an order dated 20th December 2007 in the post of Diploma Engineer Electrical as temporary work charge junior engineer on a lump sum of rupees 8,000. The petitioner has been allowed to continue to work till 31st October 2015 and services have been terminated. According to the respondent, it is only a termination simpliciter as the petitioner did not have the requisite qualification. The petitioner has possessed the degree in possessed Bachelor of Science in Applied Information Technology only in the year 2011. So even assuming for the sake of argument that the petitioner has cleared the examination in 2009, on the date of appointment, on 20th December 2007, the petitioner did not have the required qualification. Admittedly, after the discharge from service, the petitioner has taken up employment. According to the petitioner, the respondent has filed a counter stating that the degree certificate was fake, which is ultimately held to be incorrect. When the respondent has permitted the other candidates who have been selected along with them to take up the examination, and that the petitioner have completed advanced diploma in software engineering from Aptech Computer Education, Shillong, and BSc Applied Information Technology from Sikkim Municipal University, Shillong, on the day when the candidate have been asked to appear for the resident examination by a communication dated 19th August 2015, depriving employment amounts to discrimination, arbitrary, and smacks victimization. To further submit that there is no reason for discharging the services, even assuming that the order of discharge appears to be simple, having extracted work for 8 years, the respondent has not paid any compensation or gratuity, and that the petitioner would be entitled to the relief. The respondent Advocate General would submit that for the services rendered from 2007 to 2015, payments have been made to the petitioner. The salary has been paid to the petitioner on monthly basis, and that there is no arrears of payment. Full stop. The petitioner is not interested in going back to employment under the respondent. He is interested in only compensation. The respondent is an industry within a meaning of Section 2G of the ID Act 1947. Full stop. The respondent has also not complied with Section 25F of the ID Act 1947. Even assuming for the sake of argument, the termination solicitor is justified. That apart, the petitioner is also not paid gratuity for the actual services rendered. Full stop. In order to give, according to the petitioner, the respondent will have to pay approximately 3 lakhs towards compensation for illegal divesting of the duties of the petitioner from the services. Admittedly, the petitioner has joined the services on which date he did not possess a qualification. Full stop. He has been given a chance to write the examination in 2010, wherein he failed. And he was not successful. However, he was allowed to continue. Full stop. Whether the action of the employer amounts to retrenchment, whether a juniors are continuing or not, is a disputed question of fact which cannot be gone into in the writ petition, and the remedy available to the petitioner is to raise an industrial dispute. As the petitioner is interested in only compensation, this court is of the view that leaving open all the issues to the petitioner to agitate in the matter known to law by raising a dispute, and that the petitioner is interested in accepting the compensation of gratuity, he directs the respondent to release the payment of gratuity to the petitioner. As according to Advocate General, the Payment of Gratuity Act is applicable to the respondent. The gratuity shall be paid within a period of 30 days from the date of registry of the order. And that the petitioner would be entitled to interest on the gratuity in terms of Section 7 within bracket 3 capital A and Section 8 of the Payment of Gratuity Act 1972. The petition is disposed of.
All right. You have to kindly give me 60 days, my lord, because we have to calculate and all. And this order should not form precedent in other matters.
What is there, Mr. Amit, to do with? Sir, see, 8,000 divided by 26, multiplied by 15, into years of service. That is all. The same amount will be their interest. Because in terms of Section 8, the gratuity amount cannot exceed the principal amount.
Grateful.
From daily list, item number 1.
Yes. Yes. Item number? Every one.
From the main list, sir. This from the main list.
Main list, huh? How many done? 2 supplement lists, huh? Okay. Yes.
May I please, my lord? My lord, here the petitioner was dismissed from service, my lord.
Dismissed from service?
My lord. He was in BSF, serving as a constable, my lord.
Sir?
Serving as a constable, my lord.
Constable?
My lord.
What is the reason for termination?
My lord, absence without leave, my lord.
Absence without leave. How many days?
305 days. 305. 305 days.
305 days. When did he join? Where is the list of days, Mr. Counsel? In the previous case, he has rightly done it. Your friend who argued the case previous matter, he has given the list of events. It will be easy for us to follow. So you are dismissed from service. You are a constable. Yes. When did you join?
My lord, I joined on the 24th December 1997, my lord.
24th December 1997.
My lord.
Joined.
My lord.
Yes. When was the termination?
My lord, the termination was on 2015.
So, in a single matter, ask them to, saying that advocates are requested to give the list of events. Yes.
My lord.
24/12/1997 joined. When was the dismissal?
My lord, on 31st August 2015, my lord.
31st August
2015, my lord.
2015 dismissed for
5 days absence without
305 days absence. Any inquiry was conducted?
My lord, they have conducted an inquiry, my lord.
So they have to conduct inquiry.
My lord, my lord.
Yes.
My lord, I have submitted all the medical documents to the inquiry.
About medical records. What happened?
My lord, they have not accepted that.
They have not
Accepted that.
They have not accepted. You are suffering from diabetics.
My lord.
Yes.
Diabetes and other.
Yeah, diabetics. Yes.
They have not accepted, my lord. Which has resulted into dismissal from service, my lord.
Oh, that is right. Diet pride, leave 52, because these alone have been given to you. If the regular medication given to them, then how can you, if every diabetic patient is going to take leave, then 50% of the employees will go on leave.
My lord, there should be a willful absence, my lord. The absence was not.
What do you mean by willful absence? So you can take any number of days, it should not be willful. Then if you join today and continuously go on leave by giving reasons. Yes.
My lord, I have sought extension also, my lord.
Extension?
Extension of leave from the.
Extension of leave, that has been rejected.
Rejected, my lord.
Yes. What is your designation, sir?
Constable, my lord. Head constable.
Constable.
My lord. My lord.
Where is the inquiry proceedings? How do you attack the findings of the inquiry officer? See, scope under 226 is very limited. There's a Gnanasekharan or Gunasekharan case is there, and unless it is shockingly disproportionate, the court cannot interfere. It doesn't mean that in all the posts, we can say, hold that is shockingly disproportionate. There are sensitive posts where you will have to be there, you will have to be present.
Inquiry report.
Yes, where is the inquiry proceeding? Where is the finding? Where are the defects? What are all the defects?
My lord, the inquiry report, process, they have not supplied me the copy, only the portion of the statements.
Portion of the?
Statements of the witnesses has been given to the petitioner.
Where have you pleaded?
My lord, page 13.
30.
13, my lord.
13.
Para 9, my lord.
1 minute, sir. Oh, yes. How are you entitled to a assistance of a legal practitioner?
My lord, the rules say so, my lord.
Rule says, if the charges are serious in nature, provided respondent engages, the department engages the lawyer, only you will be entitled to a lawyer. Otherwise, you will not be entitled to a lawyer.
My lord, that's if the rule says so, my lord.
Where is the rule? So you must be ready with all those things. You cannot be asking questions. Shall you continue after lunch? Get prepared. Come and argue.
My lord, I pray, my lord, if can.
No, it's not required. These are all not required. If we come to the conclusion that is shockingly disproportionate, we'll interfere. If there is any defect, we'll remit it the matter. If the procedure contemplated is followed, you will deliberately dismiss the writ petition. That's all. These are the 3 things we can do.
My lord, if it come on Monday, my lord, I will set on Monday, my lord.
How many cases are there on 18th? Civil sitting?
9 cases. 9 cases.
9 cases. Tuesday? 19th?
2 cases.
2 cases. But today itself we can argue. Well, I will read. Both of us can read together.
My lord, I require some.
I'll be your junior.
No, my lord.
Instructing you.
My lord, in this matter, what happened, my lord? He was, because he was court-martialed, my lord. He was tried by a court-martial, my lord.
Oh.
And there he pleaded guilty, my lord.
We pleaded guilty. Where is that?
I have the records, my lord.
So, that's the end of it. So, pleaded guilty, that's the end of the case. Come. There is no need, we can go. Peacefully, you can go for lunch. Yes. See, in all labor and service matters, list of events is very, very important. Very, very important. See, you pleaded guilty before the inquiry officer. This inquiry, is it not?
My lord, before the security force court, my lord, it is something like court-martial, my lord.
That's what, this is the inquiry proceedings, is it not?
My lord, he pleaded guilty there, my lord.
He pleaded guilty. There are a number of judgments. When you plead guilty, that's the end of it. Recent judgment of Madras High Court is there. Before I came here, I passed order. The city and region with Raj Pega. Shafiq, Justice Shafiq. Admission. I think sitting with Justice Shafiq, we passed an order. That's all. I put Lala. It's order result, pass orders. Yes. No, orders reserved. You can send it. No, if anybody is ready, I can come again. This is the second case, huh? One case is over.
Milord, item 5, Milord, otherwise we are ready, but it'll be better if I prepare a list of dates, Milord, because this matter has traveled up to Supreme Court. I'll just prepare. Let it come up next week, Milord.
Yes, post.
Item 5.
Week commence. Post the matter after the week commencing 18th March. See, ensure that, some of the matters are taking time. So, 5 cases, they give disposal 5 cases, that is enough. Good for me.
My lord,
may I play, my lord?
This matter would come up on the week commencing 18th.
Yeah, this would.
You want it on 18th?
Well,
after the week commencing, yes. You are on the other side.
I am for the others. Obliged.
Joint request, Milord.
My lord, number 2, my lord.
My lord, I prefer item 6, my lord. I prefer item 6, my lord. I'll prepare a list.
How many
Item
cases are
6, my
there
lord.
today? 6 cases, yes.
My lord, let it come. I'll prepare the list of dates. Let it come after 2 weeks, my lord. I'm not keeping well. After 2 weeks, my lord.
Your Lordship, I beg to mention item 3, Your Lordship. Let it come after a week, Your Lordship.
Post after.
Highly
Should prepare the tabular column in such. See, don't take another adjournment, because already we fix a date, and today you are taking time. Want to dispose of. In my list, there are about 48 matters, single sitting. If you,
I assure your Lordship, I'll
finish
wait
all
your
if you argue the case, I'll finish all the 48 cases in one day.
My lord, next date I will finish it. Item 6.
Only one matter is left, my lord. Item number 2, my lord. I am for the respondent.
Number 2, I have also not prepared the list of dates, my lord.
This is a very simple matter. No, the list of dates is not required in this case.
What is the issue?
But this is regarding recruitment of a cook, my lord.
My lord, the brief facts of the case.
When he was asked for test, my lord, he was asked to cook something, my lord, he could not cook properly.
This is not the case. No, this is not the case. This is pertaining to.
I have not understood what he said. In the meantime, you interfered.
This pertains to, apologies, my lord. This pertains to a recruitment which was carried out in the CRPF, my lord. What happened, my lord, brief fact is that pursuant to the advertisement issued in the year 2015, my lord, I had given my application. Thereafter, my lord, I was called, I received a call letter. I went, it started with the physical test, my lord. So I qualified the physical test. Thereafter, my lord, I was rejected on the ground that my domicile certificate which I produced is fake, my lord. And my lord, challenging that, I have filed representations also, my lord. But however, my lord, challenging that, I have approached this honorable court. My lord, thereafter, a finding was given that my domicile certificate was genuine, my lord.
Genuine?
Yes. It was not. My lord, they came to a decision without even verifying the facts, my lord.
Yes.
So thereafter, my lord, this honorable court allowed me to continue with the selection process, my lord. Now, thereafter, in the second round, my lord, what happened? I was again, my lord, called for physical. I qualified for the physical. Then thereafter, I sat for written test. I qualified in the written test. Then subsequently, my lord, I had to sit for trade test, my lord.
Sit for?
Trade test, my lord.
Trade test.
Trade test. No, my lord, they have disqualified. It's a post of cook, my lord. Thereafter, my lord, they have disqualified me in that post, my lord. Now, my contentions are that, my lord, I have been denied a fair chance. Apart from that, my lord, they already had a grudge against me, my lord, not to allow.
Because you approached the court.
Yes, my lord.
All the things, the prejudices.
My lord, prejudice.
That's not correct.
My lord,
when he was asked to cook.
No, if you are ready, you can argue the case in the afternoon. It's not a problem at all.
My lord, only one difficulty which I have come across today, my lord, with all genuineness, my lord. What had happened, my lord, in the first round of litigation, that I have to bring it to the notice of this honorable court, my lord. Now, because as far as the genuineness of the domicile certificates which is issued by the state, my lord, state was made a party in the first round of litigation. So, my lord, today when I went through the order, my lord, I was the counsel for the state respondent in the earlier writ petition, my lord.
You cannot appear.
So, my lord, otherwise, of course, it may not have any bearing, but I will leave it to my lord.
Yeah, you don't know. Suppose there is a conflict of interest, then it will be a problem.
The question of conflict of interest will otherwise not arise, my lord, because that issue otherwise is settled, my lord. Whether it is the domicile certificate is genuine or not, that matter is settled, my lord. But it is my duty.
As a lawyer, you can appear in both sides, doesn't matter, but in the same case, you can't appear for both sides.
No, my lord, this is the second round of litigation. The first round of litigation is matter stands closed, my lord.
That is right, but it's the same issue, is it not? It's a continuing issue.
It's of course.
You have to take a call. It's a continuing. Suppose you get a verdict against you. Your client should not say that you already appeared, so you colluded with them. Suppose such allegation comes, what will happen?
Of course, my lord, I'll because otherwise I will be fighting with you, my lord.
Suppose such allegation comes, then it will be very difficult to know. You must be very careful.
My lord, because otherwise I will be fighting this case, my lord, against the respondents, my lord. The question of collision is not there, but my lord.
Whether the tiny depositor is a workman or not was an issue in one matter. The went up to Supreme Court has rendered a finding in Indian versus Bank case. He appeared for Union Bank or United Bank of India.
My lord.
The two names, one name is Koshi Kittikaran, Liaquat Ali Khan, two cases. I only appeared for the workman. He is a senior.
My lord.
He asked me to appear for the workman. We succeeded. He appeared for Indian Overseas Bank against the principal, saying that he is not a workman. The other person, some other person was not a workman.
My lord.
Then he got a favorable order in that case. The matter came up before the division bench, after the 20 division bench. So he was not in a position to appear either for the workman or for the management, even though he appeared for different banks. One for the employees of a different bank and one for the bank. It will be a very difficult situation at this stage.
So, my lord, another aspect, of course, is that, my lord, here state is not a party in the second round.
Huh?
State is not a party, my lord. So, my lord, I'll leave it to my lord.
No, we can't. You argue, we'll listen, pass orders, whatever it is. Tomorrow, you should not be blamed by your client, that's all. You argue. I have no hesitation at all. Whoever is going to argue, what is there in black and white, I am going to pass orders, that's all.
So, my lord, if that be so, my lord, I will, if some time is granted, only to have that consultation with my client, my lord. If he is ready with it, and my lord, if this...
Then we'll pose the matter to the week commencing 18th.
My lord.
In the meantime, list
of dates also I will prepare, my lord.
Yes. The request of the petition.
2015 recruitment, my lord.
Huh?
2015 recruitment, 9 years have gone, my lord.
My lord, never.
But recruitment is going on, is it not?
Yes.
But my lord, he will be overaged by now, my lord, whether he is physically
my lord,
If he is eligible, we'll say give him. If he is not, if he is going to be eligible for future vacancy, we'll say relax the age. That is all. I think he passed an order recently. I think sitting similar division bench. So we passed order. Every year vacancy has got to be identified.
Yes, I appeared in that, my lord. I appeared in that.
Every year vacancy will have to be identified and filled up. So, see, you may not know who is going to die, who is going to resign.
My lord.
You may not know. But you know who is going to retire.
Yes, my lord.
So you will identify the vacancies and prepare the list as on 31st December.
But he's given,
but there is a judgment. There are two judgments. One by Justice Cowles, taking a different view, and the other one, I think, is referred to the judgment Y.V. Rangaya, sometime in 1978 or 1983. Y.V. Rangaya. Y.V. Rangaya case says to identify every year vacancy and fill up. And Justice Cowles, I think, has taken a different view recently. I have not got the judgment, but I know I have read somewhere.
So 18th, my lord. 18th.
My lord, a week thereafter.
18th.
18th, my lord, I guess a lot of matters are there, my lord. Any other?
Not on 18th, we'll post it on that day, that week.
My lord.
18, 19, 20, 21, we'll post it in one of those 3 days.
Well.
Because 21, everyone will be going out of station to enjoy the holy holidays.
Well.
Yes. So, 20th. 20th.
Item number 4.
Deeply.
Obliged, my lord.
Is there? It's 2019. Yes.
May please, your lordship.
You ready?
My lord, yes.
My lord.
You will come in the afternoon?
My lord.
My lord.
Or we'll take it on 12th.
My lord.
Only case. How many cases were there on 12th?
10 cases.
Huh?
10.
10. How much? 3 cases. 13.
My lord.
Deeply obliged.
Obliged, my lord.
Yes, sir.
Item 6, my lord.
It's been adjourned.
My lord.
Been
My
adjourned.
lord.
Because
Obliged.
you mentioned it, you take
My
the,
lord. My lord.
yes. Post, we said post after 2 weeks. You take the date afterwards.
Obliged, deeply obliged.